Hi, California probate attorney Scott Grossman here, and today I'm discussing heirship proceedings in probate. An heirship proceeding is just another name for a petition to determine who it is that's going to inherit from the estate. And this can be used whether there's a will or no will for that particular probate estate. Now, in determining who's going to inherit, what we're really talking about is either there are particular problems with the way the will is written, or there are circumstances that have arisen that either make the outcome under the will unclear, or even the outcome without a will unclear. This is not a substitute for a will contest, and I really want to emphasize that. If you're looking at doing some kind of probate court litigation because you believe that somebody's trying to put a will into probate and that will is just invalid from the outset, that is a completely separate proceeding. And don't believe that this is some kind of alternative to it. It is not. If you come in and you file a petition that says, well, the will's invalid and that's why I need you, judge, to determine who's going to inherit, your petition's going to get dismissed on some type of motion because it's simply improper. It's simply the wrong vehicle to accomplish what you want done. If you're actually determining heirship, then you've got to file this before the probate estate closes, meaning if there is a petition that's been filed to distribute the estate, you don't get to come back after the fact. You've got to file your petition before that petition to close the estate has been granted. And I'm going to give you a couple examples of where this can come up. This is actually a pretty flexible proceeding. I could sit here for quite some time giving you a laundry list, but I don't think that's really helpful. So let's assume that you've got an estate and there is a will. But there's something unclear about the will. For example, the will talks about leaving property or some specific property to my children. And that's great. If there's somebody who comes in who says, hey, I'm a child that nobody's ever heard of, well, there may be something that you weren't aware of. There may have been a prior marriage that was never spoken of. There could have been an illicit relationship. If somebody comes in to say, look, I am the biological child and I can prove it, it doesn't matter that, say, the two kids of the decedent have known all their lives that they were sister and brother. The fact that they didn't know that there's a third person, well, that gives that third unknown child the ability to come in to say, well, when Dad said he was leaving everything to all of his children, I want to be included as one of his children. So now the court's going to have to determine whether, in fact, that person who's making the claim is indeed a child of the decedent. This could be used by a spouse where there's a question about the characterization of property. So, for example, if a person has died and they're saying, I leave all of my separate property however it is they are, and the claim is that all the property in the estate is separate property, the spouse may come in to say, no, there's some portion of this that is community property, and I want my share of the community property. Or they may make the claim because it's community property, it doesn't pass through the will, it passes in some other manner. If you've got an estate where there is no will at all, then we may get into questions about what exactly the family tree is, especially as we go further and further out. Usually it's pretty clear when we're talking about things like children and grandchildren, maybe even spouses. I've had some really unusual cases where we've had to go way, way out, where we're getting into third cousins, fourth cousins, and so forth. And it may be the family tree isn't entirely clear. There may be a disagreement within the family about exactly what the nature of the relationships between these people are. And if so, that's something that's going to have to be proved to the court so the court can determine exactly what the relationships are and therefore who inherits because there is no will. So, if you have something that does not involve challenging the underlying will itself, but it affects who it is that will inherit, whether there's a will or there is no will, you're going to want to file a petition to determine heirship, particularly if it affects you and you're the one who needs to invoke this proceeding in order to inherit yourself.